Hi, this is Cora Stack here. I'm on your side. I just wanted to just mention before what I want to talk about now are the papers that I've written over the past few years, which seem to be getting the most attention worldwide, and it suggests there's a definite dire need for change in this area of law, which is family law. So it's centers around papers which address a concept which I'm gradually trying to develop in my mind: trauma informed problem solving family justice, why an interdisciplinary panel model is gaining global attention. So before I do that, I just want to mention that I listened to John Waters' podcast last night, and he talked about neo-feudalism, and he also talked about, that he'd looked at quite a number of the judicial decisions or judgments in the Iraq Burke case. And like myself, he doesn't have any personal involvement with the Burke family, but he's been following it on the sidelines like myself. And yeah, he identified that a lot of the judgments were more or less singing off the same hymn sheet, not necessarily suggesting collusion, but it was if there was a narrative that all the judges had to follow, which contradicts really the independence of the judiciary. Now, it doesn't mean it means that each judge has to adjudicate on the rights or wrongs or merits of the case on an independent basis. And he mentioned, I think it was Judge Flaherty in the Court of Appeals, that seemed to be the only judge that seemed to present got to the kernel of the issue. And it now seems that she was correct. And I had heard a long time ago that she was very fair towards the litigants. She was a very fair-minded judge. But sure, isn't that what all judges should be? Fair. All judges should be fair. I mean, you shouldn't be Judge Flaherty is the fairest judge, or apparently the fairest judge in the Burke case. I mean, all judges should be fair and balanced. So it's just to think that only one judge seemed to, according to John Waters, and I don't want to, seem to get to the kernel of. Well, that's very disturbing. That's very disturbing. And in fairness, I have heard that Judge Flaherty is fair towards litigants in person, but if every second litigant is a litigant person, where does that leave the litigant in person? He did talk about neo-feudalism, and he's very philosophical, and I feel it's very unfair that he's no longer working for the Irish Times, because he has a deep intellect. He's very philosophical, and he has a lot to offer, in terms of journalism. So I feel very sorry that this has happened to him, and I would urge the Irish Times to invite him back in again and not muzzle him in any way. Now, I'm obviously he's a very literary person, very well read, and he offers a different perspective, and we need that. I mean, I write papers. I'm all about different perspectives, and he has it. I think he's articulating what a lot of people. He's very good for. He has a great sense of what the ordinary person is suffering or experiencing, and why would that perspective be excluded from journalism, mainstream journalism? This is a very serious question for democracy. So I'll let that go. But I definitely think he had a very strong point in saying that he had looked at a number of the judgments in the Burke case and found almost all were singing off the same hymn sheet, which seemed to contradict the principle that each judge should adjudicate independently on the different cases. They shouldn't be backing each other, or feeling perhaps they have to back each other. That's the other thing. Maybe a young female judge, for example, goes in there, feels that she can't speak out because, her something will, like it's playing the game it's in a lot of institutions. I can't say this for definite, but I think he has a point. But the point is that I'm raising a question about a sequence of techniques and doctrines that were used to undermine or to put me in a position where I was at that point had no longer access to justice, and I am saying that was contrary to Article 34. So if that was accepted on my case, that would strengthen the individual independence and give the individual judges more of a sense of that they have to be independent, and that they should not be subjected to undue pressure from other judges or from more powerful judges, or some people call it the shadow government. Now, I don't know who these powerful judges are. I don't know anything about, but I could say that in a lot of institutions there's this fear. There's a culture of fear. If you go against the tide. That brilliant book, Against the Tide. So perhaps that's what John Waters has done. He's gone against the tide, and anyone that does that pays a huge price. So let's hope we'll get back into the Irish Times, or in due course. So not that the Burkes are win the game, but that John Waters wins the game, if you want to call it, by being invited back to present the alternative view to the public, so that the public can decide based on different perspectives, judge themselves. So across multiple democracies, family justice systems are under visible strain. Courts are overloaded, litigation is prolonged, children experience instability. I'm particularly concerned about the effect on children because of the current family law system worldwide. And sustained patterns of psychological domination and coercion are often not identified earlier or are processed as ordinary bilateral conflict, especially now with the no-fault divorce. The question is not whether individuals within the system are committed. The question is whether the architecture of the system is optimally designed for modern family breakdown. This is why a trauma-informed problem-solving dispute resolution model led by an interdisciplinary panel before adversarial court escalation, and that is mandatory, is gaining global attention. It's not ideological, it's architectural. In many jurisdictions, including Ireland, the United Kingdom, Australia, Canada, the United States, family cases typically begin with adversarial findings, applications, affidavits, counter-allegations, interim hearings. But modern family breakdown involves trauma, fear, financial asymmetry, information imbalance, extended family fracture, child vulnerability, stress, mental health issues. There's the world of there's a lot of power asymmetry there, power imbalance in family law. Not just financial asymmetry is part of the power imbalance, but that's a huge part, power imbalance, and this has not been sufficiently recognised, I think. Some cases involve structured, sustained patterns of psychological domination and coercion, including financial control, fear-based compliance, and strategic relational manipulation. Gaslighting, we might call it. Yet adversarial first systems frequently assume relative equal parties engaged in a symmetric dispute. That's what no-fault divorce does. It's an easy option for the courts. That assumption does not always hold. The access gap, lay litigants, and complexity. This is another structural issue. The current model is increasingly difficult for lay litigants to navigate. It's procedurally complex. If you look at Erie versus Ireland, for example, Mrs. Mary Robinson took that case, and you wouldn't hear it now. You'd never hear it mentioned, because it was an excellent case, but it hasn't been implemented. No, it hasn't been implemented because the vast majority of people in the middle classes can't afford to get legal or denied it. So there's a ruling, but it's not being implemented. Sure. So the current model is called Erie versus Ireland. A lot of people think that's criminal. The current model is increasingly difficult for lay litigants to navigate. It is procedurally complex. It is legally technical. It is financially demanding. Not everyone can sustain long-term representation. Complex family breakdown cases involve layered psychological and relation dynamics, are time-intensive and very expensive to litigate. So there's a lot of money to be made out of it. As a result, across jurisdictions, many individuals are unrepresented, underrepresented, financially exhausted, or disengaged from the system entirely. Large swathes of people live with unresolved disputes and grievances with no accessible early forum to ask, can this be stabilised before escalation? When unresolved disputes accumulate, they do not disappear, they compound. The reform that I'm suggesting now, if you saw the pictures here done by, they're brilliant, like they're actually brilliant. Sitting around a table with computers and talking collaboratively. At reform, the exact opposite to up there and down there. Sitting around a table in a collaborative, with experts that will keep the temperature and will do the problem solving or assist the couple with problem solving first. So a trauma-informed problem solving dispute resolution stage. So the reform, this is getting a huge amount of interest worldwide. So it's common sense, really. But the reform introduces a mandatory state-funded trauma-informed problem-solving dispute resolution stage before adversarial court proceedings. At its centre is an interdisciplinary panel. A panel may include a legally trained chair, a trauma-informed psychologist, a child developmental specialist, financial or governance expertise where required. Its function is not adversarial adjudication, it is structured assessment and stabilisation. What the interdisciplinary panel does or would be designed to do: early screening for sustained pattern of psychological domination and coercion, differentiate high conflict from systemic imbalance, maps financial and information asymmetry, assesses child developmental risk, designs this is the most important part, designs a stabilisation pathway. Escalation to court remains available and essential where required, but escalation would occur only after structured assessment, which includes designing a stabilisation pathway and having that, giving that time to see could that work, not before. Why this matters for children and extended families. Family law affects more than two litigants. It affects children, grandparents, granddaunts, granduncles, extended families, cousins, friends, schools, communities. In highly adversarial environments, children can become drawn into litigation dynamics. They may feel pressure to align, and you often hear this weaponized, they're weaponized to align with one party for all kinds of reasons, but it often can be because the party that the children are weaponized against loses because of the the way the narrative would go, that the children want to be with the one parent, but they could be weaponized for years to do this, you see. So this would not be recognized by the courts. That's called parental alienation. They may become part of evidential positioning rather than being shielded from it. I mean, that's the terrible part about the whole thing. The way the children can be used as pawns or manipulated, and it can happen from a very early age, and it certainly doesn't stop at 18. It's like a cult, it could go on for life. That carries developmental risk. This is the problem. A trauma-informed interdisciplinary model would hopefully, and that would be part of the design, identify relational risk factors early, reduce adversarial incentives, and protect children from procedural escalation. Early structured assessment makes escalation-based strategy less effective and less attractive, so it rewards different behaviour. This is not about removing courts. Let me be absolutely clear. This reform is not about getting rid of courts, because I'm actually saying we need judges, or that type of level of intellectual, we need that type of person in this interdisciplinary panel, like the level of a judge, not a quasi-legal judge, a judge, a real judge, that level of judicial expertise is needed in this interdisciplinary panel. So that's what I'm saying, both to be supported by people with financial expertise, psychological expertise, trauma, and all of that. So, because it's impossible to expect a judge to be able to, be that interdisciplinary, with caseloads, building up like this every day. So let me be absolutely clear. This is not about removing courts. This reform is not about getting rid of courts. Courts remain essential. Judicial authority remains essential. Well, I'm saying we need the judicial type of person, the Mary Farty type, in the Judge Mary Farty and others like her in this model. So legal accountability, or legal professionals of her ilk, legal accountability remains essential. The reform introduces a necessary and affordable layer of structured dispute resolution before adversarial escalation. You might say that this could also apply to other areas of law, but I think in particular the first stage where it's absolutely necessary is family law. This is what's coming across now from my analytics, and it's been read. I mean, the amount of people reading this, and it's phenomenal. But I think it's because it's resonating. There's a huge need. People aren't reading this for fun. there's a huge need for it. So it's the world giving me a message. So I'm putting it out here if I'm to be, trying to see what is the message here coming through from the analytics. It improves sequencing. It strengthens course by reducing over